Harini Law Circle மாணவர்கள் அனைவருக்கும் என்னுடைய வணக்கம். I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 10 of our target to complete 50,000 multiple choice questions in law. If you haven't seen our previous 9 parts, I request you to visit our channel or check out for the links in the description box. These 50,000 multiple choice questions will give you the confidence to crack any legal examination which is conducted in your state or in the national level, be it the civil judge examination, judicial magistrate exams, special legal officer exams, or the district judge examination. You will be able to give your 100% in your performance. These 50,000 questions have been divided into 1,000 parts to make it easy and comfortable for you in your preparation. The only favor that I ask from you is that I want you all to share this session or the video from our channel to students, juniors, friends who are not able to afford a proper coaching or join a proper mock test series and prepare themselves better for these kind of examinations. So in that way, you would be able to help these students and it will benefit the entire society. And the students of Harini Law Circle are the most privileged kind of students who are part and parcel of these 1,000 sessions who would in their future clear the upcoming preliminary examination which you attend. So with that note, let's start with our first question of the series. Which offense is constituted under section 366A of the Indian Penal Code? Kidnapping, kidnapping for begging, procuration of minor girl, importing of girl from Jammu and Kashmir state. So basically in this session, we'll have the answers directly displayed on the question with the answer in the options. This is because we are not attending a mock test right now. We are preparing ourselves for the exam. We are studying basically. Instead of having hefty books on our table and scrolling down multiple pages on PDF, it is better that you read a question and you see the same question on your screen or on your paper in your examination. So in that way, it will be very useful for you so that you have already come across the same question in our channel. So the correct question to this answer to this question is procuration of a minor girl is mentioned in section 366A of IPC, which criminalizes the act of procuring a minor girl under 18 years, which by inducing her to go from any place or to do any act with the intent or knowledge that she may be forced or seduced to illicit intercourse with another person. So this section is basically aimed at preventing trafficking and exploitation of minor girls. The offense is punishable with imprisonment up to 10 years and fine, and it is also a cognizable non-bailable offense which is triable by a court of sessions. So these explanations will carry more content than what you see in the question itself. Okay, so I want you also to stop for a while, pause at this particular moment, read it thoroughly until you get the point on your mind, and then move to the next question. See, the video might be half an hour, 1 hour, or any time. You pause for a while, read, and move to the next question. You just spend another 10 to 15 minutes of your time to spend on the entire video, including pausing and reading on these explanations. The second question, where a compromise was arrived between parties to a suit by playing fraud, misrepresentation, or mistake, and a decree was passed with the consent of the parties, then the suffering party may select which one of the following alternatives for setting aside such decree. So the correct answer is through a second suit. So the remedy is through a second suit. So order 23 rule 3 of Tnpsc says, with the consent or decree passed under this particular order, it can be challenged by a separate suit if the compromise is alleged to be vitiated by fraud, misrepresentation, or mistake. So this principle was upheld in the case of Pushpa Devi Bhagat versus Rajinder Singh and others. And the third question on our screen is a match with the list. So you have to match list 1 with the provisions in the list 2. So interpleader suits is under section 88. Letter of request is under section 30. Precepts is under section 46. And power to order is under section 77. So I have given you the appropriate correct sections in the explanation. I want you to pause and read and memorize it. The fourth question, you have to point out the incorrect statement. So a member of the parliament is not entitled to exemption from personal appearance in the court. So an MP is not exempted from personal appearance in court. Is it true? Incorrect. Right. He is exempted. He is exempted from personal appearance. Moving ahead. Under the Code of Civil Procedure 1908, Section 56 says, no woman shall be arrested and detained in civil prison in the matter regarding to the decree which relates to. So, a woman who is under a dispute or a decree which relates to which kind of dispute may not be arrested or detained. So, a woman who is involved in a family dispute and a decree is passed may be arrested. Matrimonial disputes, yes. Legitimacy of children disputes, arrested and detained, yes. But on payment of money dispute, a woman shall not be arrested under section 56. So the appropriate case to this particular point is Cyril Brito versus Union of India. I want you all to pause for a while and read through the question. So this will give you more clarity. See, we already know what the question means and what the answer is. But to get a better clarity, in case if you don't get what it means, then you have to obviously read through the explanation to be able to comprehend the question. And in case such a kind of question appears in your examination, it will be very useful for you as well. Moving ahead to question number 6. Which one of the following is not a mode of abetment under the Indian Penal Code? Attempt, instigation, aiding, conspiracy. So the Indian Penal Code under abetment, it specifically states abetment can be through instigation, aiding, and conspiracy. An attempt is not a mode of abetment. Okay, you don't abet someone through an attempt. So section 107 of the Indian Penal Code says about abetment, which is an offense that may occur in case these three ways are followed: instigation, conspiracy, or aiding. I have given you the meanings of all these three terms. I want you to pause and read. As I said earlier, attempt is not a mode of abetment, where attempt, which refers to trying but failing to commit a crime. Common provisions with regard to offences of attempt is mentioned in 511 of IPC, where other specific provisions in relation to attempt to murder or any other independent offense is mentioned in 307 and other provisions of Indian Penal. Moving ahead to the 7th question. A and B sue C for recovery of 1000. So C has drawn money from A and B. Now they want to recover it from C. C has a debt due to him by A alone. So now A alone has a debt which is due by A. In this situation, A can, what C can do? In this situation, what C can do? C cannot set off a debt due to him by A alone. So when there is a common debt which is due by C to both A and B, and there is a debt which is due by A alone to C, C cannot set off the debt which is due by A alone, that now C has to pay A and B. So that is a different case of contract, and this is a different case that can't be done. So D is the correct answer. So order 8 rule 6 of CPC says about set off when to be allowed and when not to be allowed. So the parties must be the same. In case the set off must be between the same legal parties in the same capacity, that is the plaintiff versus the defendant, as you usually know it. The claim must be for an a certain sum legally which is recoverable, and the set off must be reciprocal by both the parties who are liable to each other in the same capacity. So in the previous question, what happens has been uh, given to you in more detail. I want you to pause, read the entire example, which is based on the previous question, which we saw on the screen, previous slide. So pause for a while, read, and move to the next question. Okay. If you haven't comprehended what it says, you will better understand from the explanation. Moving ahead to question number 8. Inherent powers conferred under section 151 of the Code of Civil Procedure 1908 may be exercised by the Supreme Court only, High Court only, District Court only, Supreme Court, High Court, District Court, as well as by any civil court. So the correct answer is any civil court. What section 151 of CPC says is that nothing in this code shall be deemed to limit or otherwise affect the inherent powers of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of process of the court. So the key points that you need to keep in your mind is that under section 151, the inherent powers are not limited to any particular court, and all civil courts are eligible to take cognizance on a civil case. Moving ahead. Under the Code of Civil Procedure, which one of the following is not exempted from personal appearance in this code? So CPC tells certain people are not they are exempted from personal appearance, and we have to now find out who is not exempted. So as we know that the Minister of the Union, Minister of State, the Vice President, President, all these people are exempted. The judges of the Supreme Court and High Courts, they are also exempted. The chairman of public service commissions are not exempted. For example, the chairman of Tnpsc or UPPSC or SSC, they are not exempted from personal appearance. Now we know that the SSC case is going on, and there have been wide protests with regard to the SSC, and there is a case which is pending right now in the court with regard to the pattern change and the exam mode change, the question setters change, adequacy being into play. So there is a national dispute problem which is going on with respect to the staff selection commission. And in case if the court wants the staff selection commissioner to be present on a summons, he needs to be present. He is not exempted from personal appearance in the civil court. So this is mentioned in section 133, which mentions who are all exempted from personal appearance under order 27A of the Civil Procedure Code. So have a quick read of the explanation and move to the next question. Consider the following statements, and now we have to find out which statements among these are incorrect. Where the High Court calls for the record of any case in its revisional jurisdiction, it operates as to stay of such case before the subordinate court. See, a subordinate court handles a case, and now suddenly a High Court calls for the record of a particular case as a revisional jurisdiction. It cannot stay the case which is pending before the subordinate court. Only upon the orders of the High Court, one can stay the case which is pending before the subordinate court, but not on any other instance. Okay, on calling a record of a case, it does not automatically operate to stay a case in a subordinate court. So the first statement is wrong. As we know the first statement is wrong, we eliminate option B, 2 and 3. Moving ahead, no second appeal shall lie in money suits where the value of the subject matter does not exceed rupees 25,000. So this statement is correct. So 2 is right. So we eliminate option A, which says 2 is incorrect. So A and B is eliminated now. Now we have to understand if 3 and 4 are right or wrong. A plaintiff cannot be allowed by the court to sue afterwards for any relief omitted by him in the suit. The plaintiff can be allowed. The plaintiff can be allowed by the court to sue afterwards for any level relief omitted by him in the suit. Okay, so they have wrongly mentioned it. So the third one is also incorrect. As we see, there are only two statements which can be wrong in C and D. So the correct answer is option C, which is 1 and 3 are incorrect. Moving ahead. 11. The documents on which the plaintiff relies upon in support of his claim shall be filed by him in the court along with the plaintiff, along with the plaint actually. So see, a plaintiff files a case in a court and he files some documents for his claim. So he needs to file it along with the plaint. Only then the case is taken up. And this supporting document along with the plaint is submitted for the reference of the defense, because the defense, once summoned, they need to start framing the written statement on their defense. So for this purpose, the documents are attached along with the plaint. Moving ahead to the next question. So I want you all to pause and read the question, the explanation carefully. Moving ahead to the next question. Under the Code of Civil Procedure 1908, objection to jurisdiction as to the place of suing shall not be allowed by the appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity and there has been a subsequent failure of justice. So all these objections apply. Order 7 Rule 10 of CPC, which is related to judicial interpretations, which says that an objection to the territorial jurisdiction where the place where the suit is filed, which cannot be raised for the first time in an appeal or revision, it is to be entertained by the appellate or revisional court. Such objection must have been raised before the trial court, that is the court of first instance, taken at an earlier possible opportunity, not delayed or weighed. There must be a failure of justice which was caused by the lack of jurisdiction. So all these conditions are not fulfilled. The appellate or revisional courts usually will not entertain the jurisdictional objections. Moving ahead to the next question. Which of the following statements are wrong? So the wrong statement here is no appeal may lie from an original decree passed ex parte. So option B is the wrong one. Let's move to the explanation to understand why it is wrong. It is incorrect because it says no appeal lie from an ex parte decree, whereas CBC says an appeal does not lie against an ex parte decree, as it is a decree passed without the defendant's presence, but it is still valid and appealable order. So it is appealable. Okay, it can be appealed. No appeal shall lie is incorrect. But otherwise, the other options are right. Just read through the other options for once. 14th question. A deposited a box of jewels with B as his agent. C alleges that the jewels were wrongfully obtained by A from him and claims them from B. Here B can institute interpleader suit against A, can institute interpleader suit against C, can institute interpleader suit against A and C both, can institute an interpleader suit against A and C both. So the reason for me to read all the options is that sometimes there might be confusions or error in choosing the questions, choosing the options. So for that not to occur, when you writing the examination, it is compulsory for you to read all the options even though you are confident about a particular answer. Just once read all the options and apply to the question and see in case if it is right or wrong. There might be small words that change in the options that will put you into great struggle or lose marks. So the correct answer is can institute interpleader suit against A and C both. So an interpleader suit under Order 35 of Civil Procedure Code, which allows a person, usually a stakeholder. A stakeholder means a person who is interested in the particular property, or who has an interest in the particular case, which allows a person who is a stakeholder, who is in the possession of the money or goods but claims no beneficial interest in it, to ask the court to decide between two or more parties claiming the same goods or money. So in this particular case, B is a stakeholder holding the jewels but does not claim ownership. Since both A, the depositor or the agent, and C, the claimant alleging wrongful possession, claiming the jewels, so B can institute an interpleader suit against both A and C. In case if a case is filed, the court will then decide who the rightful owner is, and B will be discharged from liability by handing over the jewels to the rightful claimant. Question 15. Under the Code of Civil Procedure 1908, for the first time, provision for compensatory costs in respect of false or vexatious claims or defenses has been made under which section? So it is section 35A of the code. So false or vexatious claims or defenses for compensatory costs, section 35A of civil procedure. So it was inserted by an amendment act of 1999 in CPC regarding compensatory costs. Moving ahead to the 16th question. The term prescribed under section 216 of Civil Procedure Code 1908 means. So prescribed under section 2 subsection 16 means prescribed by rules. Option C is the correct answer. Moving ahead. Cognizance of the offence of defamation under chapter 21 of the Indian Penal Code can be taken. Who can take the cognizance of an offence of defamation? So you defame a person, and who can take the cognizance of the offence? On a complaint made by an aggrieved person. So the person who is aggrieved by such defamation can complain under chapter 21 of the Indian Penal Code. What is the nature of the statement given in narco test? So we know that narco test means narco analysis to find out the evidence in cases where it is not being able to solve by proper primary evidence. Narco tests are made. So what is the nature of the statement given in a narco test? So the correct answer is it is not an evidence. So it is just an aid to finding out the primary or secondary evidence. It cannot be directly used as a evidence in the court of law. So narco analysis tests, which involve administering drugs to a suspect to induce a state where they are believed to be more likely to reveal the truth. These statements made during a narco test are considered neither voluntary nor reliable as evidence because the subject's will is impaired. So therefore, such statements are not admissible as evidence in the court of law. They may, however, be used for investigative leads but cannot be directly relied upon as proof. Who can issue a search warrant to search a post office? So the answer is district magistrate. So a district magistrate can issue a warrant to search a post office. The Indian Post Office Act of 1898 says only a district magistrate or an officer specially empowered by the government can issue a search warrant to search a post office. Civil courts or revenue courts do not have jurisdiction to issue such warrants related to postal premises. This provision safeguards the sanctity of postal communication and prevents arbitrary searches. Question number 20. Justice J.S. Verma Committee report of January 23, 2013 has recommended that non-penetrative forms of sexual contact should be regarded as. We have already seen this question as part of our previous session. So the correct answer is sexual assault. So Justice S.S.J.S. Verma Committee of 2013 constituted after the 2012 Delhi gang rape case, which we commonly call it as Nirbhaya case. So which recommended the broadening of definition of sexual offences. It also proposed that non-penetrative sexual acts such as an unwanted touching or groping should be categorized separately as sexual assault rather than rape. So this distinction helps cover a wide range of sexual violence and strengthen the legal protection for victims. Moving ahead. 21. The nature of revision under the Code of Civil Procedure is that it operates as a stay of proceedings, it operates as a stay of the suit, it operates as a stay of proceedings and suit both. It shall not operate as a stay of the suit or proceedings except where such suit or proceedings is stayed by the High Court. So the correct option is option D. So under which legal position do we take it? Under section 115 of the Code of Civil Procedure, revision is a power exercised by the High Court to supervise subordinate courts to ensure legality and propriety. However, mere filing or institution of a revision petition does not automatically stay the suit or proceedings before the subordinate. A stay will only operate if the High Court specifically orders a stay of a suit or proceeding. So this we already saw in our previous question. 22. Under which section of the Criminal Procedure Code provision for security for keeping the peace on conviction exists? Section 106 is the correct answer. Provision for keeping peace. So 106 of Criminal Procedure empowers a court of session or a magistrate of the first class to require a person convicted of certain offences to execute a bond for keeping the peace for a specific period not exceeding 3 years. This provision is preventive in nature, aiming to ensure that individuals convicted of offences likely to cause a breach of the peace do not repeat such conduct. The offences specified under section 106 include offences punishable under chapter 8 of the Indian Penal Code, including sections 153A, 153B, and 154. Offences involving assault, criminal force, mischief, or criminal intimidation. Any other offence that caused or was intended or likely to cause a breach of the peace. Section 109 of the Criminal Procedure, on the other hand, deals with security for keeping the peace from persons who have been ordered to execute a bond for good behavior. It is applicable when a person is required to provide security to maintain peace, but it does not specifically address post-conviction scenarios. Moving ahead, 23. Section 183 of the Criminal Procedure Code applies to voyage on the high seas. So this is with respect to a different provision that we don't usually come across in Criminal Procedure Code. So this might be asked if the question setter examiner wants to make the question paper tough. So section 183 applies to voyage on high seas. 183 high seas. So it may occur on any vessel or a ship which is in the high seas. 24. Under the Criminal Procedure Code, for an offence punishable with fine only, the period of limitation is. So it is 6 months. So the provision directly says the limitation period is 6 months under section 468. And it is 1 year in case if the punishment for the offence is with imprisonment for a term not exceeding 1 year or with fine or with both. Then it is the limitation period is 1 year and 3 years for all other offences. Question number 25. Under the Criminal Procedure Code, examination of witness in the absence of absconded accused can be done under. So the accused absconds and the court examines the witness. Under which section is this particular situation warranted? It is under section 299 of Criminal Procedure Code. Even if the accused absconds or cannot be found, the procedure for examining witness is mentioned under section 299. 26. Statement recorded by police officer during investigation under section 161 of the Criminal Procedure Code can be used during trial for contradicting the witness, for collaborating the witness, for both A and B, neither A nor B. The correct answer is police officer's statement during investigation under section 161 can be used during trial for contradicting the witness. So section 161 of CRPC, which deals with statements recorded by a police officer during investigation, it says that such statements are not substantive evidence and generally cannot be used to corroborate the witness's testimony in court. However, these statements can be used to contradict the witnesses if the witnesses departs from their earlier version. So this helps in testing the credibility of the witness. The Supreme Court has repeatedly held these statements that statements under section 161 are primarily for contradiction and not the proving of the truth or the fact state. 27. This is a case scenario where A is an accused of an act which may amount to theft or receiving stolen property or criminal breach of trust. A is now only charged with theft. It appears that he committed the offenses of criminal breach of trust. So in this situation, what may happen? He may be convicted of criminal breach of trust, though he was not charged with such offense. He may not be convicted of criminal breach of trust because he was not charged with such offense. He may neither be convicted of theft nor the criminal breach of trust. He may only be convicted of theft because he was charged with theft. So we cannot take a mandatory rule that he will be only charged of theft as he was charged only of theft. So we will take a liberal view that he may not be convicted of criminal breach of trust. So taking a liberal stance in such circumstances will lead to the answer. So don't pose yourself in case if you're not charged for such offense. So that is what law says. So this law is based on the principles of natural justice under Article 22, Clause 1 of the Constitution of India. So the supporting case based on these cases is Sharad Birdichand Sarda versus State of Maharashtra, where the Supreme Court emphasized the requirement of proper charge for conviction to a particular accusation. And in State of Punjab versus Dalbir Singh, a 2012 Supreme Court case where the court held that an accused cannot be convicted of an offense with which he was not charged at all unless such charges has been amended and accused has been given a chance to defend on such offences as well. Question number 28. Which section of the Criminal Procedure Code applies when the officer in charge of a police station receives information that a person has committed suicide? He will immediately report to the executive magistrate. So this is mentioned under section 174. So it states that investigation of unnatural deaths, including suicide, where when the police officer receives information about death which was caused due to suicide or any unnatural cause, the officer who is in charge of the police station or the police officer who received the information must investigate the case and report to the executive magistrate immediately. So this section ensures prompt official inquiry into such deaths to rule out foul play or other causes which was the reason for the death. 29. Who writes evidence in a criminal trial? So the magistrate himself writes the evidence in a criminal trial. Okay. So the magistrate or a judge records the evidence of witnesses. The magistrate is responsible for documenting the oral testimony during the trial in the case diary or court record. So advocates who are lawyers who argue and present their evidences, but they do not write it down officially. Experts who are obliged to take the expert opinion. The magistrate needs to record these evidences, or the court clerks or stenographers may assist in the transcription, but the official responsibility lies with the magistrate. Question number 30. Under section 27 of the Criminal Procedure Code, the age of juvenile is, so 16 is the age of juveniles. 27. Next, under section 41 of Criminal Procedure Code, power of police to arrest a person. The answer is the police has powers to arrest a person is confined to cases of reasonable suspicion. Only when there is a reasonable suspicion, the police can arrest a person under section 41 of Criminal Procedure Code. Which one of the following sections of the Indian Evidence Act makes relevant opinions as to existence of customs? So, Indian Evidence Act with respect to customs is under section 48. So, this is basically based on religious customs, which are secular in nature. Moving ahead, a case scenario where X sues Y for damage done by a dog of Y, which Y knew before to be ferocious. The fact that the dog previously bitten A, B, and C are. So, a dog which was owned by Y was ferocious. It also had a previous situation where it had bit A, B, and C, and now it has damaged X. Then A sues for those damage. So, is it relevant, irrelevant, or inadmissible, or unreliable fact? So, the previous biting of Y's dog on A, B, and C, is it relevant, irrelevant, inadmissible, or unreliable? So, the answer is relevant. 34. The law of evidence consists of which one of the following? Ordinary rules of reasoning, legal rules of reasoning, rules of logic, all the above. The correct answer is legal rules of reasoning. The law of evidence is not just about ordinary or logical reasoning, but specifically about legal rules of reasoning. It includes the principles and rules established by law that courts follow to decide what evidence is admissible and how to evaluate it. Salmond on jurisprudence defines. So read this through, and you'll get better clarity. Moving ahead to the 35th question. In Indian Evidence Act, the maxim "salus populi suprema lex" is related to. So it is related to section 123. The meaning for this maxim is that the welfare of the people is the supreme law. Under the Indian Evidence Act, section 123, which relates to evidence regarding public documents, it provides that when the courts remain or examine the validity or contents of public documents, the welfare of the public, that is salus populi, is paramount. Populi, as we know, is public, and welfare is salus, is paramount. Paramount means it is very important. This principle underscores the importance of protecting the public interest and recognizes that public welfare overrides private claims in matters involving public documents and acts. 36. While exercising the power of revision under the Code of Criminal Procedure, the High Court cannot discharge the accused, acquit the accused, grant bail to the accused, or convert a finding of acquittal into one of conviction. So the High Court cannot convert a finding of acquittal into one of a conviction. So under CP/CRPC, the High Court has revisional powers to examine the correctness, legality, or the propriety of any order passed by subordinate courts. But while exercising such revision, the High Court can discharge the accused if it finds the charge groundless, acquit the accused if evidence is insufficient, grant bail in appropriate cases. However, the court cannot convert a finding of acquittal into one of a conviction during revision. So this will amount to substituting its judgment for that one of a trial court beyond the scope of revision, which is not permitted. So basically, the revisional jurisdiction is limited to trial court's jurisdiction. The principle here is that revision is superior, not appellate or a retrial. Moving ahead to the 37th question. Which one of the following is not a secondary evidence? So below are the list of secondary evidences. So which one of these are not part of the secondary evidence? So answer is option D. Lithography is not a secondary evidence. So lithography are considered primary evidences. They are not secondary because they lead to the reproduction of the original document. So it involves creating copies through printing process. It leads to the primary evidence. So it is not part of the secondary evidence. Whereas certified copies, counterparts, and other provisions or oral accounts of contents of a document are secondary evidence. Question 38. Under which one of the following provisions of the Indian Evidence Act the words forming part of the same transaction occurs? So simple and easy question. If you have read through section 6 of the Indian Evidence Act or have seen our previous parts, this one would be an easy one for you. Forming part of the same transaction is under section 6. So section 6 of Indian Evidence Act had been asked previously in various questions in multiple exams. The court may in its discretion allow a fact to be proved which is so connected with the fact in issue as to form part of the same transaction, provided that the fact so connected in such is such that it ought to be mentioned with that fact in issue or is necessary for the understanding of that fact. So this is the exact place where the phrase forming part of the same transaction appears. 39. The case Dadnath Pandey versus State of Uttar Pradesh is related to. So this case is related to the plea of alibi. Moving ahead. A is tried for the murder of B by cheating with club with the intention of causing his death. In A's trial, which one of the following is not a factor in issue? A is beating with the club, A is conversation with C, A is causing B's death with the club, A is intention to cause B's death. So mens rea along with actus reus, guilty mind along with the act leads to an offense of death or murder under section 300. So A's beating with the club is an offense, which was an act which led to the death of B. A is causing B's death with the club, yes. A's intention to cause B's death, mens rea, and A's conversation with C is in no way a fact and issue which leads to the death or murder of B. Okay, so B is the correct answer. Next question. Which one of the following does not come within the meaning of document under the Indian Evidence Act? Writing, map, telephonic talk, a word, photograph. So writing is a document, a map is part of a document, a word which was photographed is a document. A telephonic talk is not a document, right? It isn't a document, it is an evidence. It might not be, it cannot be a document. 42. Which one of the following sections of the Indian Evidence Act applies to the pleaders relating to professional communication? Section 28, 128 only, section 129 and 130, 133, 134, 126 and 127. So the correct answer is 126 and 127. Select the incorrect statements using the code below. So they have given you 4 statements and you have to find out one of these is an incorrect statement or multiple options are incorrect. So our answer is 2, 3 and 4. Let's move to the explanation directly. The first statement is correct, where Indian Evidence Act generally doesn't apply to arbitration. The second statement is incorrect, as Evidence Act does apply to proceedings before commissioner. The third statement is incorrect, as affidavits are procedural, not governed by Evidence Act. And fourth statement is incorrect, as evidence does not apply to military courts. Moving ahead to the next question. How many years old electronic record will be deemed to be proved if it is produced from any custody which the court in the particular case considers proper? The answer is 5 years. The provision itself in its first line says it is 5 years. Okay. So Section 90A, which says about presumption as to electronic records, which are 5 years old. So the heading itself gives you the answer. A blind reading of the heading will enough, is more than enough. 45. Match list 1 with list 2. They have given you provisions and the sections which go with the list 1. Burden of proof is under section 101. As we know, it is 101 and the correct answer is option C. Pause for a while and read the explanation part carefully and try to remember it through mnemonics. It will be helpful for you. Point out the incorrect statements. If a contract is contained in several letters, all the letters in which it is contained must be proved. If a contract is contained in a bill of exchange, the bill of exchange must be proved. If a bill of exchange is drawn in a set of 3, only one need to be proved. If A gives B a receipt of money paid by B, oral evidence is offered of the payment. On the payment, the evidence is not admissible. So D is incorrect. Others are right. So pause the explanation, read through all the analysis of each options, and then you will understand better. 47. In which of the following mortgage the mortgager binds himself personally to pay the mortgage money? So the mortgager binds himself personally is during a simple mortgage. Section 58B of clause B, subclause B of the Transfer of Property Act mentions what a simple mortgage is, where without delivering possession of the mortgage property, the mortgager binds himself personally to pay the mortgage money and agrees that in the event of his failing to pay according to his contract, the mortgagee shall have a right to cause the mortgage property to be sold. 48. Which of the following would be considered as transfer of property under the Transfer of Property Act 1882? Grant of an easementary right of way over a piece of land, exchange of two things, a family settlement, creation of charge on an immovable property by operation of law. So, transfer of property under the TPA 1882, exchange of two things. So, you exchange two things between two people and it amounts to transfer. Creation of charge on an immovable property by operation of law. So, a consideration is present in a transfer. Then 2 and 4 is the correct answer. 49. Which of the following case decided by the Privy Council relates to fraudulent transfers? Musahar Sahu versus Hakim Lal, Middleton versus Pollock, Union of India versus Rajeshwari and Company, all the above. So the correct answer is Musahar Sahu versus Hakim Lal. So this was a case related to fraudulent transfer. Question number 50 and last question of this session. Match list 1 with list 2. So list 1 you have the provisions and in list 2 you have the sections. Transfer of perpetuity when unborn persons acquires vested interest, transfer by ostensible owner, transfer by co-owner. So transfer by ostensible owner is a easy question. So as we know, it is section 41 through which we can eliminate C and D, and transfer in perpetuity is not usually remembered. When unborn persons acquires vested interest is also an important provision. So it is dealt in section 20. So now we come to the conclusion that B is the correct answer. So in case you know one or two options from these match questions, you will be able to answer it correctly. Coming to the homework question. Section 7 of the Evidence Act does not include which one of the following? So section 7 clearly states that occasion, cause and effect are there, and purpose is the one odd one which is not there in section 7 of the Indian Evidence Act. So with this we end part 10 of our 50,000 multiple choice question series, and I want you all to share the video as much as possible to your friends, relatives and students who are preparing very seriously for these kinds of examinations, and to your juniors as well, and see you in the next interactive session in part 11. With that, I sign off. Thank you.